Hello, everybody. Thank you for joining us today. It's really nice to know that some of you who I work with regularly have joined us. And to those who don't know me, my name's Melissa Potter, and I'm a partner in the property team at Bardia Perry. And I'm joined today with one of our lawyers, Stefan Rajewski. I'd like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land. I pay my respect to their elders, past and present, and recognise their continuing connection to our land, waters and culture. I extend my respect to the Aboriginal and Torres Strait Islander peoples here today. Before we begin, the slides and recordings will be coming your way following the presentation. My slides don't have a lot of detail. The recording will hopefully have what you would like to know, or if not, please just give me a call afterwards and I'm happy to talk through anything. If you have any questions, please drop them in the chat. And at the end, if you could please do our quick survey so that it helps us make the next one better. I'm going to talk to you today about leasing transactions. It's going to be largely practical tips. Our property team acts on varied and numerous lease transactions for our local council clients, and I'm thinking of some that we've done over the past 12 months or so. Council owns varied types of land. It's community assets, which council's leasing for value to put back into the community. When dealing with land, councils are governed by the guiding principles set out in the Local Government Act to manage lands and their assets so that current and future local community needs can be met. However, leases and other lease documents are fundamentally and essentially commercial agreements, which are open for negotiation between the parties. There are some statutory restrictions that will be placed on the leasing transactions. For example, if you're leasing community land, there's the restrictions in the Local Government Act as to use and term and community consultation. If it's a retail lease, you've got the Retail Leases Act, there's the Residential Tenancies Act, and caravan parks are governed by legislation. However, outside of that, they're fundamentally commercial agreements which are open for negotiation. Increasingly, I notice that some of the lease transactions I'm working on are becoming quite complex, with multiple agreements required to document the agreement to be reached between the parties. And some of the tenants' council of your tenants are sophisticated entities. They're experienced, they lease multiple properties, and they're not afraid to press for advantages for themselves. Sometimes they will want obligations placed on council that, if not performed, will give rise to penalties or abatement of rent. Bespoke clauses will be negotiated, such as requirements for access to buildings, such as the rooftop, or to run IT equipment through the building. And so council will need to bring a commercial hat to this, as well as their procurement guideline obligations, Local Government Act obligations, and others. So it can be a balancing act. There are various forms of documents that are required in lease transaction. First, I want to talk about the different types of land that you own. Council, as I said, owns varied parcels of land. Some are commercial for office premises, others are retail for shops and cafes. Some are industrial, former industrial land that's been cleared, and land that are greenfield sites that will be leased to tenants for the tenants to develop into their own use, such as a healthcare hub or other uses. There are also leases for community fields and uses, for cinemas and for caravan parks. All very different uses on very different types of land. And so I think you know where I'm headed here. There is no one size fits all for a lease document. There is no one precedent council will have or one form of lease that can be used over all of these uses. I know that some tenants will want to prepare the lease themselves because they think it will keep costs down and make the transaction go quicker, more smoothly. And sometimes I've been given law society leases, which there's nothing fundamentally wrong with a law society lease, but it's very vanilla and it will not be appropriate for many of the lease transactions which council are involved in. I would say that a law society lease can be used for perhaps one of the small cafes with what I'm going to call a mum and dad tenant. Certainly it won't be appropriate when there is a sophisticated party on the other side or an experienced party. And to secure blue chip tenants such as national retailers, councils may be required to use the tenant's form of lease, which will be lessee friendly, but to have a successful transaction will need to be used. There is no one size fits all lease. And a lease will often require additional agreements, starting with a heads of agreement. Even for a simple transaction, I would recommend a heads of agreement is thought about and documented. An incentive deed if council is going to grant an incentive to the tenant, a fit-out deed if the tenant's going to be allowed in early to carry out its fit-out, or if more substantial works are required and the commencing date won't be known, an agreement for lease may be required. Then the lease itself and associated licenses, such as for car parks, outdoor seating or signage. Going through these various types of agreements, let's start with a heads of agreement. There's no magic in the title of this agreement. It's sometimes referred to as a leasing proposal or a heads of term. But I think of this document as maybe the foundation on which the lease transaction will be built. And so I'd encourage you to take the time to put as much detail in a heads of agreement as possible, because it will certainly make the drafting of the lease and then the negotiation of the lease terms a lot smooth. It will become more smooth. It will be difficult if you have a heads of agreement to add new terms in later if they're not included in the heads of agreement, or to suddenly change your mind and not want a term that's been put in taken out. So I'd say the document should be specific. It will include your basic parties, term, rent, description of the premises, whether there's an option, whether outgoings are payable, but go further than that and think of other matters such as repair obligations and in particular make good. Leases are all about specifying obligation and balancing the risk between the parties. And so this is the good opportunity to think about who bears what risk for what purpose. Heads of agreement, I would say, should typically be non-binding. They must certainly state whether they're binding or not. Failure to state this will likely result in an agreement for lease or an equitable lease being formed, which can be enforced by either party. And councils, I have had several matters over the years where once we've started to negotiate the lease documents, the parties realise they don't want to be in a relationship with each other and want to walk away. If the agreement's not expressed, if a heads of agreement is not expressed to be non-binding, this will be difficult. Also, council itself, because of decision-making within council or different uses or needs for the building, may want to withdraw from the transaction at any time. So beware to specify whether or not the heads of agreement is to be binding or not. An agreement for lease is typically required when you don't know what the commencing date will be, because it's going to be subject to completion of certain works, whether by the tenant or the landlord. As with all lease transaction documents, make sure that they are detailed. Include plans, include specifications. Take time to agree the plans and specifications with the tenant before the parties sign the agreement. Sometimes if the plans cannot be prepared before the agreement is entered into, the agreement will need to step through how that's going to be agreed and at what time, who prepares them and presents it to the other for agreement, and what happens if the parties can't agree. Avoid conditions such as the parties to act in good faith to agree, because an agreement to agree is largely unenforceable. And so then you're left in no man's land with potentially a binding agreement, but not able to agree on the types of works or the specifications of the works to be carried out. Depending on the complexity of the agreement, build in milestone dates. If approvals have to be granted, build in the dates by which those approvals need to be obtained and what happens if they're not obtained or aren't obtained on terms acceptable to the parties. Will it be appropriate at that stage, and it probably would, for the parties to be able to terminate the agreement and walk away? Ultimately, these agreements for lease will have a sunset date, and that date should be fixed. So it's a drop-dead date. It may be able to be extended by, say, up to 6 months or so if there's an event of delay that can give rise to extending the sunset date, but it cannot and should not be able to be extended indefinitely. Delay events should be considered. For what reasons can this milestone dates or sunset date be delayed? It will be things like inclement weather, not being able to get building materials, delay of the approving authority. Specify the events of delay. And I do sometimes see you'll have them set out and then they're catch-all at the end, any other event of delay. But no, it has to be specified so that there are parameters and scaffoldings for the parties. Should I be using that?
Yep, so we think we got up to...
all of these photos are things that the team has worked on in the past. So you might...
I think we're up to here, won't we?
Yes, thank you. You might recognise them from your own LGA. Okay, so back on to agreements for lease. And then, of course, what's practical completion? When are the works practically completed? What does that look like? Who's going to certify it? Will an occupation certificate be required for practical completion? Or will council itself as landlord certify that the works have reached practical completion? Of course, I am aware that council will be wearing two hats, as landowner and as consent authority. But what I'm talking about here are the obligations on council just as landowner. Council documents will have non-fetter clauses so that its role as consent authority is not fettered. But as I said, these are the commercial obligations being placed on council as landowner. An agreement for lease will also sometimes set out how the rent is to be calculated, because the premises, if the rent is a rate per square metre, the size of the premises may be subject to survey, and the rent will need to be calculated. Insurances are important. If a tenant's going to go on to carry out works, we need all of the lease insurances in place before they're allowed access. And of course, the security under the lease should cover any works they're doing under the agreement for lease. Councils will sometimes grant incentives, whether that's rent-free, a rent abatement over the term of the lease, or a contribution to fit out, or a combination of all of the above. These are typically put in a separate incentive deed, which will specify how and when the incentives will be paid. For example, if it is a contribution to fit out, think through when will the payment be made. Will it be made by instalments, or will it be made in one lump sum? What evidence will council require before it hands over funds? Invoices from contractors, site inspections to make sure the works are in place. And if a tenant defaults, the incentive should be suspended until that default is remedied. Or if once the lease commences, the lease is terminated because of tenant default during the term, should the incentive deed allow for the incentive to be clawed back at that time. Any clawback clauses need to be carefully considered so as they aren't a penalty, because if courts think it's a penalty, it won't be enforceable. It needs to reflect the real loss council will incur as a result of the lease not following its full term, which the incentive thought that it would. In addition to the lease, there will often be licenses. As I said earlier, they will be for car parks, seating areas, whether it's outdoor seating or maybe in the lobby of a council building. There might be signage rights or storage rights. Licenses will be required because perhaps the area forms part of land, like a car park, and if the license is for more than 5 years, if it was a lease, more than 5 years, it would require a subdivision for lease purposes. Or perhaps the boundaries of that area are fluid, such as seating in the foyer of the council building. Or the area will be used in common with council and other occupants or tenants of the building. Licenses will contain provisions and obligations similar to those found in a lease. The repair obligations, things that the tenant is not allowed to do in those areas, and also what happens at the end of the lease. What are the make good obligations? Obviously removing cars, perhaps cleaning up any oil stains, with seating, removing furniture, not leaving any mess in that area, leaving it clean and tidy. In relation to signage, you would want the signage removed and any damage caused in removal made good. To avoid multiple documents, these licenses can sit within the body of the lease, but it is a license, which is a contractual right between council and the tenant. It won't run with the land the way a lease will. And so you would need to specify that it could be assigned to any assignee of the lease. Then we come to the big document, the lease. All the usual terms that you would be familiar with is, rent. Think about rent review. If it's a long-term lease, you would want the rent, I'm sure, to come back to a current market rent review at some stage. Outgoings. Sometimes because the buildings have been used or occupied by council themselves, you mightn't be aware of the actual external outgoings paid in respect of that building. So some investigation would be needed so that we can properly document the outgoings. And of course, land tax. Council won't pay land tax, but once it's leased, land tax may become payable directly by the tenant. Think of repair. What's the standard of repair? Will it be to bring the premises back to the condition they were in at the commencement of the occupation? And beware there, not the commencement of the lease, in case there are option leases. It will be the date the tenant first took occupation. And if that's the case, get a condition report or some other photographic evidence so there can be no dispute as to what the premises look like when occupation first took place. Or should the tenant be required to bring the premises back to base build? Or if it's a development site and the tenant has built the improvements, which would be aging at the end of a long-term lease, should the tenant be required to demolish the premises and hand back a vacant site to council? And of course, with repair, that old chestnut, who's responsible for the structural repairs and who's responsible if there's a leak in the building? Some tenants will require specific obligations on council to be responsible for those items, and failure to comply with those obligations could lead to consequences. One of the areas we are repeatedly asked to advise on are the make good obligations under a lease. And I would suggest that you make them as specific as you can to avoid any uncertainty at the end of the lease. And then security under a lease. Remember, the security is not just to cover non-payment of rent. Sometimes, quite Substantial leases, I'll see only 3 months security. But it's not just for non-payment of rent. It's if they fail to carry out repair obligations or the tenant fails to carry out its make good obligations. And it's to protect council from loss it may suffer, any loss that may at the moment not be able to be quantified because of the tenant's default. And the default obligations themselves should spell out what happens so that there's no confusion as to when and how council can issue default notices and, if need be, terminate the lease. And of course, there are some unique terms that can be hotly negotiated. Firstly, can I start with big commercial tenants will try and always ask for a right of first refusal if the property is ever going to be sold. I push back on that. One, I just don't like them from a commercial point of view. I don't think any landlord should be constrained as to how it disposes of a property later in time. But specifically with council, given the principle to get the best use and price out of this asset, I don't think council, and the procurement guidelines, I argue that council cannot be able to agree to these rights of first refusals. I have seen them in heads of terms, and then I pedal back to get them out of the lease. Sometime on one occasion we have had to agree to one, but that's just one area that I find I do negotiate a bit, and so maybe be upfront at the beginning that they won't be granted. Insurance provisions can be negotiated if you have a large tenant who has global insurance and doesn't want to take out specific insurance for these particular premises. That's acceptable, but council's interests should still be noted, and even certificates of currency supplied periodically. Sometimes access through the building is very important for tenants. And you'll know those common clauses where council as landlord will contain control over the common areas and be able to close them or redirect pedestrian traffic. These are sometimes hotly negotiated where tenants will not allow access to be hindered or denied, or pedestrian traffic flow through a different means. Lifts, some tenants will press that only one lift at any one time can be out of order, and that they must function at all times, that services must function to specifications between certain temperatures, and failure for the services or lifts to operate can lead to rent abatements. Contamination is often an issue that is negotiated and thought about a bit. Also in relation to licenses for access, when developers are allowed to go on to use council land to develop their own land next door. Contamination extends not just to what the tenant may bring on or do on the premises, but also what they might disturb. There may be some pre-existing contamination that, but for the tenant or the developer's use, would not be disturbed, and remediation action would not be required. In that case, that risk and that responsibility should sit with the tenant. Contamination that might migrate onto the land may need to be council's responsibility because the tenant has no role to play there. And increasingly, we're seeing bespoke clauses such as green obligations to ensure energy efficiency, anti-slavery provisions, and some tenants insisting on access to EV chargers. This is often with the bigger tenants. They'll have a checklist that their documents must have green clauses or anti-slavery clauses, and so they will be included in the lease. And then this is just more of lease management as opposed to setting up a lease transaction. But if the lease with option leases, when an option is exercised, make sure that a new lease is entered into. Sometimes, we will look and the new lease hasn't been entered into. Once an option is exercised, that will give rise to an enforceable agreement for lease or an equitable lease. If council wants to later sell the property or more likely enforce the provisions of the option lease, if the lease is not a legal document, but is an agreement to lease or an equitable lease, it can become more difficult for council to enforce the obligations under that lease. So always enter into that option lease and get it signed and, if necessary, registered between the parties. Now, some of you might have some questions, but we're going to hand over to Stefan to talk about caveats. And then if you let us have your questions at the end, we can answer them then. Thank you.
Thanks, Melissa. Some very valuable nuggets of wisdom there on navigating different types of leasing transactions, different transaction documents, and some of the important terms that need to be considered. So, as Melissa said, I'll be talking about caveats today. They're a pretty interesting area of property law. They're a source of a lot of confusion and a lot of disputes, and they're a very valuable tool when you know how to use them. So just a bit of an overview of the roadmap of what I'll be talking about. I'll be giving a bit of an overview of the main type of caveats. A caveat is caveat against dealings, what they are, what the elements of a valid caveat is, the concept of the caveatable interest, which is essentially the fundamental requirement for having a valid caveat, and how to consider drafting agreements to provide for caveatable interest to make sure that they stand up to challenge, some of the risks associated with lodging caveats, whether that be compensation or otherwise, and some practical tips when considering when you might want to lodge a caveat in the future. So what is a caveat? So you probably know about what a caveat by what it does. It's not something that's actually defined in the Real Property Act, but it's essentially a recording that prevents registration of dealings on title without the caveator's consent. There's different types of caveats under the Real Property Act, and they're essentially described by what sort of action they prohibit. But the most common type of caveat, and which is what I'll be talking about mostly today, is the caveat against dealings. And that essentially prevents the registration of dealings on title that affect the estate or interest that the caveator claims. So, for example, let's just say that the caveator claims to be a purchaser under a contract for sale. That caveat would prevent the registration of transfers to other parties that aren't the purchaser without the caveator's consent. It just kind of illustrates the effect of that type of caveat. The courts have also described the caveat as a form of a statutory injunction preventing registration of dealings, and that's an apt description because what a caveat protects is a claim to an interest in land. It doesn't establish that interest in the land, and ultimately, if a caveat is challenged, the caveator will need to go to court and prove that that interest exists in order for that to be vindicated. So that's where that description comes from. And because the caveat is recorded on the title, any person dealing with the title will see that the caveator's claim is there and need to factor that in to their decision to dealing with that title. I guess the last element of a caveat is what it is not, is it is not an interest in the land. It is a device for protecting an underlying claim to an interest in land, and it's more of an administrative device that prevents registration of dealings. So for a caveat to be valid, we're essentially considering two things: the underlying requirement or the entitlement to lodge the caveat, which is essentially its substance, and how it's prepared, what information it needs to include from a formal perspective for it to be acceptable for lodgement. So the key entitlement to lodge a caveat, which is ultimately what would need to be justified in court is having a recognised legal or equitable estate or interest in land. This is commonly referred to as a caveatable interest because it is these types of interests that are the subject of a caveat, but this is just kind of a shorthand that's used to refer to them. So I'll go through this in a bit more detail in some of the next slides, but I'll just say that there are many different types of caveatable interests. Some caveatable interests are capable of being registered on title, such as leases, mortgages, easements, and so on, and others can't be registered. For example, interests that people might have under a trust. All of these types of interests can be protected by caveats, and determining whether an interest can be protected requires an examination of past cases and determining whether a certain scenario fits within those previous cases. So in order for someone searching the register to understand the effect of the caveat, it needs to comply with certain formal requirements that are specified in the Real Property Act. Now, it doesn't need to strictly comply with all of the requirements, and the courts have got the power to overlook some minor formal defects, for example, maybe errors in spelling and so on and so forth, something that doesn't detract from being able to identify what the underlying claim is. But if there's an error in how the caveat's prepared that affects the ability for a third party to identify what the caveat is actually protecting, it may not hold up to a challenge to lapse it by a third party. So some of the main formal requirements that are relevant are properly identifying the party that has the interest in the land, providing an accurate address for service of notices, which are relevant to parties seeking to lapse or have the caveat withdrawn, making sure that the land is accurately defined. So this is important, particularly when dealing with leases or other rights such as easements, which do not affect the entire parcel of land and maybe only a part of it. If the caveat extended to the whole land and a lease was only for part of it, that would potentially be a defect that would invalidate the caveat if it was challenged. And perhaps the most important information from a formal perspective is the particulars of the underlying legal estate or interest in the land, which I'll touch on in a bit more in a moment. It's important to ensure that the information that's in the caveat is as accurate and detailed as possible to define the exact nature of the estate that's claimed and the facts that establish it. So related to that, really the linchpin that determines whether or not the caveat is going to stand up to a challenge is the caveatable interest that's described in the caveat and how it is described. So when we're talking about the caveatable interest, there's really two aspects of it. There's the nature of it, which is at a general level, what type of interest is it? And so that's kind of illustrated by the examples that we have here on the slide. So the nature of the interest would be the interest of a tenant under a lease, or the interest of a grantee under an agreement to grant an easement or a covenant, or a charge or mortgage under an agreement, or perhaps a caveat that's created by an agreement that's not covered by one of the above options. So what all of these interests have in common is that they grant rights in connection with the land that are not just personal between the parties. And any caveatable interest will need to have that in common in order to be valid. So to illustrate what an error of substance would be in the example of a lease that would potentially invalidate a caveat, let's say, for example, that the agreement to grant the lease didn't actually grant the tenant a right of exclusive possession, but something less, such as a license over a car park area or another area. Contractual rights such as licenses are personal between the parties and would not satisfy the requirement of being an interest in land that could be protected by a caveat. So whenever thinking about lodging a caveat that relates to an agreement, we need to look at the agreement as a whole and whether the rights granted is personal between the parties or confers some sort of right that's related to the land that can be enforced against third parties and which could be enforced by a court of equity by seeking equitable remedies. So some other examples of caveatable interests that are particularly relevant to councils, which I'll cover in the subsequent slides, arise from agreements. So particularly whether statutory agreements, such as voluntary planning agreements, have the capacity to provide an interest in land. Whether that's the case will really depend on the wording of the legislation. And if the legislation doesn't say that the agreement is an interest in land or has the status of an interest in land, we need to consider how we can draft the document to provide for that sort of protection. So I guess the core feature of a caveat is, what does it actually stop? So the most important prohibition that caveats can enforce is on registration of dealings that affect the estate that the caveator claims. So when preparing a caveat, there's a few different options of dealings that you can prohibit. You can't just prohibit all dealings with the title. There needs to be an actual connection between the right that you're claiming protection from and the dealing that needs to be the dealing that you're seeking to prohibit. This is particularly relevant when an application is brought to lapse the caveat or extend it, because the court will consider whether the particular dealing that's lodged will affect the caveator's claim, and it may actually just permit the registration of the dealing. So it's important to appreciate that the caveat isn't just a blanket prohibition on dealing with the title. It's always specific to the nature of the underlying claim. So what are some of the situations, I guess I've touched on some of them, where councils might want to consider lodging a caveat? So because a caveat can protect interests which are capable of registration on title, this is really where the value of a caveat lies, because without a caveat, having an unregistered interest in land, such as a signed but unregistered lease or a signed but unregistered agreement to grant an easement, there is no way of protecting yourself from a subsequent third party acquiring an interest in land and an indefeasible title. Under the Real Property Act, the registered proprietor takes free of most unregistered interests which are not reported on title. So if it doesn't have notice of your lease or your requirement to grant an easement, it may not be bound by that lease or that easement. So registering caveats to protect these valuable rights, to ensure that if any party wishes to buy the land, they're on notice that underlying interest exists, and that they would have notice of that, and essentially, because that interest arose earlier in time, they would not be able to disregard it, even though it's not registered on title. But the ultimate objective, even if registering a caveat to notify the world that there's an underlying interest in the land, is to have that underlying interest registered so you can take advantage of the benefits of indefeasibility for yourself. So with planning agreements in particular, I might just go to the next slide. So with planning agreements in particular, the provisions in the Environmental Planning and Assessment Act that allow for planning agreements to be registered don't actually specify that the agreement itself is an interest in land. And because planning agreements did not exist outside of statute, unlike leases or easements, which had characteristics as an interest in land before the Real Property Act existed, we need to think about how we can provide for an interest in how we could provide for an interest in land within the terms of the agreement itself. I've seen a lot of agreements where that contain clauses that a party agrees to someone lodging a caveat. I've just seen a few questions here. I'll address that question at the end, Helen. Thank you. That allow for a party to lodge a caveat with consent, right? But one of the things that I covered earlier is that a caveat has to actually have an underlying interest in the land to support it. So if there's an agreement to permit a caveat to be registered, if the agreement as a whole can't be interpreted as providing some recognized estate or interest, that clause may not be valid. So what's the way around this? So a common way around this is to include a charging provision. And a charging provision to be valid actually has to secure some sort of monetary or other obligation. And in the context of a planning agreement, the enforceability of the planning agreement against third parties and subsequent owners of the land happens once it's actually registered on title. So the real value would be to include a provision that secures the developer's obligation to register the planning agreement on title, or it could also relate to the provision of a bond or a contribution under the agreement, because those amounts are monetary in nature. That type of provision would permit a caveat to be lodged. However, one thing to bear in mind is that once the relevant obligation is performed, the underlying interest that supports that caveat falls away. And so it's important that when that interest falls away, because the entitlement to maintain the caveat's no longer there, that councils promptly remove that caveat to ensure that they don't expose themselves to compensation. And really, once the planning agreement's registered, you have the benefit of the notice that the caveat provided, as well as the enforceability against subsequent owners. So its value and use is kind of diminished at that point. So I'll just quickly touch on some of the ways that caveats can be removed. Really, the most relevant of these is the lapsing notice process. So the lapsing notice process is the way that the most common method that the owner of land or the party that holds the interest that's affected by the caveat will seek to have the caveat removed. It's an inexpensive process that involves sending a notice in the post. And there's a very short period in which to respond, and failure to respond and seeking an extension from the court to the caveat until a final hearing will mean that caveat will lapse. And if that does lapse, you will not be able to lodge a further caveat relating to that same interest without the leave of the court or without the caveator's consent. And why would the caveator consent when all the caveat does is clog their title and prevent them from dealing with their title? So it's really important that when you receive a lapsing notice, that you act on it quickly and so that you don't lose the protection, which could be quite valuable for certain types of interests. The other ways of withdrawing a caveat are voluntarily. So, I mean, if the caveat's no longer has a valid interest that supports it, removing it voluntarily is the smart and prudent thing to do to prevent yourself from being exposed to claims of compensation. Or applications can be made to the court to withdraw the caveat, which usually usually parties do this when the removal of the caveat is very urgent and they can't wait the 21 days for the caveat to lapse. So the main risk that's associated with caveats is kind of related to the underlying interest in that it protects, which is compensation where a caveat's been lodged or it hasn't been withdrawn without reasonable cause, or in rare cases where a caveat's been lapsed, where you've got no reasonable basis for disputing the interest that's being claimed. Now, compensation could be quite extensive in the context of a development. So, for example, if in an off-the-plan development, a caveat is maintained where under a planning agreement where lots and settlements can't proceed because the caveat's in force, but the caveat doesn't actually have an underlying interest that protects it, that supports it, sorry. You know, the sorts of losses that the developer could claim would be very substantial, including financing costs, penalties under the contract. If contracts get terminated because of delays to completion, the scope for liability could be quite significant. And in most cases, the failure to withdraw the caveat without reasonable cause, the main thing that's relevant here is whether the caveat had an underlying interest in the land that was valid, which supported it. If the caveat doesn't have an underlying interest in land that supports it, that's the primary consideration in whether there's a reasonable basis for maintaining it. So, like I touched on earlier, if a caveat's been registered under a VPA for the purpose of remaining until that VPA itself is registered, not removing that caveat could potentially expose councils to significant compensation from the developer. So what are some of the key takeaways when drafting and considering whether to lodge a caveat? So the purpose of the caveat is to protect holders of unregistered interests from being defeated by a subsequent registered proprietor. So when someone acquires registered ownership of a property, they take that estate free of most other interests that are not recorded on the register. So lodging a caveat before that, make sure that parties are on notice that there's an unregistered interest in the land and that they will have to address that when acquiring that property and they won't be able to disregard it. Another thing to be aware of is ensuring, and this is a bit of a boring administrative point, but you'd be surprised how much trouble this causes, is ensuring that there's an accurate address for service of notices. So the address for service of notices is where a lapsing notice will be served to remove the caveat. And I've seen examples where caveats have specified addresses for law firms and they've moved offices, or perhaps it might be to an accountant's firm and they've moved offices. They don't have a fixed premises. The party serving a lapsing notice only has to serve a notice at that address by post. They don't need to ensure that that notice is received. They just need to send it to that address. So ensuring that the address on the lapsing notice is an address that's reasonably permanent and that doesn't change regularly and which is monitored regularly is absolutely critical if you maintain a large number of caveats. Because as I said, if the caveat lapses, you won't be able to lodge a further caveat about the same interest without leave of the court. Moving on from that, making sure that the interest in the land supports the caveat, that there's an underlying interest in land which supports the caveat when drafting the agreement. So making sure that you check off that the interest in the agreement falls within one of those relevant categories, whether it be a charge, and it has all of the required elements that the case law specifies to satisfy that interest. And lastly, making sure that caveats are removed once the underlying interest in the land has been registered on title and has the benefit of indefeasibility, which is really what the torrent system is all about. It's about having a registered estate in land, which runs with the land and which has priority over unregistered interest holders. So I might just go through the chat now and see the questions we have. So Helen asks, an underlying interest would include outstanding rates and charges as well. So under the so this is for outstanding rates and charges. Yeah. So I think with that particular right, the legislation provides for a charge, a statutory charge. Now I'll need to come back to you specifically on what other protection you may be able to get for that, but you may actually be able to register a charge over the property, which would provide greater protection than a caveat itself. So, but we'll look into that further and come back to you.
You could lodge a caveat. Yeah.
Do you have any other questions for myself or Melissa?
Nope.
Doesn't look like it.
Okay, well, thank you all for joining us and listening. As I said at the beginning, please, if you would like to discuss anything or have a chat, please contact us. That's fine. Otherwise, thank you again for listening.